Hello students, today we are going to take up the topic Contract of Indemnity. This is a major position or composition of the Indian Contract Act 1872. Under this, let's understand first what is indemnity. So, a contract by which one party promises to save the other from loss caused to him by the conduct of the promiser himself or by the conduct of any other person is called contract of indemnity. Basically, indemnity is a contract under which one person, that is the promiser, there are basically two parties under this contract. One is the person who is promising to make good the loss of the other, and the other party whose loss is so made good. So, we understand that promiser, that is the party who is making good the loss, will make good the loss out of the act caused by whom, by the conduct of whom, by promiser himself, or by the conduct of any other person, or by any other natural calamities. So that is termed as what? Contract of indemnity. So let's understand how many parties are there. There are basically two parties under the contract of indemnity. First, the person who promises to save the other from the loss. That is the party who is giving the promise to the other party. That is the promiser who is giving the promise of to the other party that in the course of an happening of an uncertain event that they are covering under the contract, the losses that the other party, that the promisee will face, will be taken care by the promiser. That party is termed as what? Indemnifier. And the person whose loss is to be made good is called indemnified or indemnity holder. That is the other party to whom such promise is made for the occurrence of that event. The party who is making good the loss will pay the amount or will make good the loss of the other party. That other part, that is the promisee, is termed as indemnified or indemnity holder. Basically, let's understand what all contracts come under the contract of indemnity. The contract of insurance comes under, basically covers under the indemnity contract, but leaving aside the life insurance businesses. All the general insurance business will come under this. And furthermore, whenever we go for a parking or whenever we go for a custody, and when we are transiting our goods from one place to other in form of railways or airways, that consideration comes under what? Under the contract of indemnity. So basically, let's understand when Mr. A takes an insurance policy for covering his bike for any loss caused due to theft, fire, etc. That contract between Mr. A and supposedly Oriental Insurance Business is termed as contract of indemnity. So here Mr. A is indemnified, that is the indemnity holder, who is getting the indemnity by paying a minimal sum of known as premium, and this Oriental Insurance Company is termed as indemnifier. So, if by chance the vehicle is lost due to theft or is damaged due to fire, the amount will be paid by the Oriental Insurance Company, that is the indemnifier, as the company or the indemnifier has promised to make good the loss of the indemnity holder. So, this is termed as what? Indemnity contract. So, all insurance contracts except the life insurance contracts come under the contract of indemnity. In simple terms, indemnity is bringing back to the same position to the other person, that is the promisee. We have to bring back the promisee into the same position as he or she was before the happening of the event. So that is making good of the losses so suffered by the promisee. Further, we understand rights of indemnity holder. Rights of indemnity holder when the contract of indemnity has occurred or certain damages has been caused to the indemnity holder and he has borne some kind of losses. First, he has to pay out of his pocket. The indemnity holder, like in insurance contracts, we first pay the amount of whatever we have incurred, then the claim is settled for our amount. So similarly, the indemnity holder has certain rights. First, all damages which he may be compelled to pay in any suit in respect of any matter to which the promise to indemnify applies. If supposedly the indemnifier, that is the insurance company, in the same example, the insurance company rejects or does not give the damages, so does not approve the claim and does not pay the indemnity holder for the amount. In that case, if the indemnity holder undertakes any kind of suit against the indemnifier for making good such loss, in that case, all the damages that he is compelled to pay for filing the suit, that is, whatever amount that he has incurred during that course of the suit, that amount will be undertaken, will be repaid by whom? By the indemnifier. Second, all costs which he may be compelled to pay in defending such suit, provided he acted prudently or with the authority of the indemnifier, along with all the damages in the form of any further losses that he has suffered. Along with those damages, all the costing, that is the cost of the lawyer, that is the cost of the proceedings, whatever cost the indemnity holder has to incur by filing a suit against the indemnifier for making the payment, all that will also be repaid by whom? By the indemnifier. And lastly, all sum which he may have paid upon compromise of such suit, provided the compromise was not contrary to the order of the indemnifier and was prudent or was authorized by the indemnifier, along with all the damages and the cost, all the losses and the cost, all the sum that both the parties, that is the indemnifier and indemnity holder, have come into a compromise and have decided the sum of money with the consent of the indemnifier and with the authorization, all that sum along with the losses and the cost will be paid by the indemnifier. Next, the next most important part along with the indemnity is the contract of guarantee. Contract of guarantee, as we all know, the guarantee is a very common term. We all know about it. Like when we go for a bank, opening of a bank account also, we need a guarantor, right? Similarly, when we go for taking a loan, that time also the bank asks for a guarantor. Similarly, in a normal course of business, if we lend money from somebody, we still require a guarantor who will make good the loss or who will repay the amount in case the debtor defaults. Again, here are three parties. One party who is lending the money, that is termed as creditor. The other party to whom such debt has been given is termed as debtor. And the third party who is assuring the creditor about the repayment is termed as surety or guarantor. So let's have a look at the definition of guarantee. A contract of guarantee is a contract to perform the promise or discharge the liability of a third person in case of his default. So basically, contract of guarantee is a promise given by a person to discharge the liability of a third person in case if that person is unable to make the payment or to fulfill his liabilities. Let's have a look at the example. A advances a loan of rupees 5,000 to B, and C promises to the A that if B doesn't repay the loan, C will do so. This is a contract of guarantee. A has given a loan to B of rupees 5,000, for which C has assured to A that if B is unable to make the repayment of the loan, that amount will be paid by C. So, thus, this is a contract of guarantee. As given by the definition, we have three main parties. First, the person who gives the guarantee is called surety or guarantor. Second, the person in respect of whose default the guarantee is given is called principal debtor. And thirdly, the person to whom the guarantee is given That is, the person who is lending the money or is giving certain kind of amount to the other party, or has arose with some kind of liability to the debtor, that person is termed as a creditor. Okay. So now let's have a look at the certain essentials of a valid guarantee. So first and foremost, before becoming a contract of guarantee is a contract. So it must possess all the essentials of a valid contract, be it offer and acceptance, be it legal consideration, lawful object, capacity of parties to contract, free consent, etc. It should contain all these 10 essentials of a valid contract. Then only it will turn into a valid guarantee. Contract of guarantee. So it includes this is the first essential of the contract of guarantee, that must possess all the essential elements of a valid contract. As the basis of agreement of guarantee is, first and foremost, it is a contract, so it must have all the essentials of contract. Second point is three parties and three contracts. As we have seen in the contract of guarantee, we have three parties, namely principal debtor, creditor, and surety. So, hence, we will be having three contracts simultaneously, like a contract between creditor and debtor for getting the loan, a contract between debtor and surety for giving the assurance of repayment, and a contract between the surety and the creditor for acting as a guarantor against the repayment of loan in case of debtor's default. Hence, we are having three parties, hence three contracts. Your next essential is, in the guarantee, the primary liability is of principal debtor. Basically, the liability of surety will arise only and only when the debtor defaults in the payment. And furthermore, the surety has given the assurance to the creditor when the loan has been taken by the debtor. So, foremostly, the primary liability will fall onto the shoulders of the principal debtor. The liability of surety arises only in case of default by principal debtor. Hence, the primary liability should be of the debtor. Like, for example, if Mr. A takes a loan from bank, hence the primary liability is the loan, and loan amount has been taken by the principal debtor, that is Mr. A, for which C has given assurance for repayment in case of A's default. Hence, the major liability falls, or the prime liability falls, onto the shoulder of the debtor first. And surety will not make payment before the payment of debtor. The foremost liability will fall for the debtor when he is unable to make the payment or he defaults in making the payment. In that circumstances, surety will make the payment. So the prime liability or the primary liability is basically of the debtor. Second, the next point is, a contract of guarantee is invalid. The guarantee has been obtained by means of misrepresentation made by creditor. If by any way a guarantee has been obtained by misrepresentation, so it will be treated in the same way as in that case, in the case of a contract. In a contract, there should be a free consent. Free consent, that means a consent should not be caused by certain elements in which misrepresentation is also a form. So, consent caused by misrepresentation makes the contract voidable or invalid. So, hence, a contract of guarantee, if it has been obtained by means of misrepresentation, it will be treated as invalid, as the creditor has hidden certain facts, be it innocently, be it unintentionally, but the guarantee is not valid because the parties have not understood the same thing in the same sense. That is, the identity of mind is not there. That is why this particular thing makes, if the consent of guarantee has been taken by misrepresentation, it makes the contract as the surety has not given his consent for a misrepresentative statement. Now let's have a look at the nature and extent of surety's liability. Until which extent the surety will be liable in case of any default, or what are the liabilities that will be arisen against the surety. So, firstly, the liability of surety is secondary. As we have seen, the debtor has the prime liability. When he takes the loan, or when he lends certain amount, or when he arrives with some kind of obligation, then only this particular guarantee has been given. So, the liability of surety is basically secondary. That is, he is liable only on the default of the principal debtor. Until and unless the principal does not default, principal debtor does not default, the surety is not at all liable to make any kind of payment against the guarantee. Second, the liability of surety arises immediately on the default of principal debtor unless there is a provision in the contract that the creditor must first proceed against principal debtor or must give a notice of default to surety. Basically, the liability of the surety arises immediately as the principal debtor defaults in making the payment. Like for example, for the repayment of the loan of Mr. A, it was decided that he will make the payment on 30th of May. But on 30th of May, he made himself incapable of giving the loan amount. So in that case, from that moment, the liability of surety would arise. Until and unless there are certain provisions which has been mentioned in the contract that the creditor must first proceed against the debtor, that is, must first ask for any kind of excuse from the debtor or may give some extension of time, or must give a notice of default to surety, or the creditor should inform the surety that his liability has arisen. Until and unless such clauses are not mentioned, the liability immediately arises as the principal debtor makes a default. Next, surety is not liable if guarantee has been obtained by misrepresentation. Again, as we have seen, when there is misrepresentation, that is, there are certain facts which has been prompted wrongly to the surety, be it innocently or be it intentionally, then in that particular condition, surety's liability is nullified. That is, he is not at all liable. Why? Because the consent so forced by him was caused by misrepresentation. Hence, his consent is not free. So, a contract without a free consent is invalid or void. That is why the surety will not be liable against the guarantee if such guarantee has been obtained by misrepresentation. Next, surety is liable even if the principal debtor has been discharged. Though the consequences, the principal debtor has been discharged of his liability, but still surety has given the consent for the liability, hence he will be liable. Like in the case of minor, if a minor child has taken a loan from a bank for the education, the minor child that is the debtor, the debtor will be discharged from his liability, but the guarantor, maybe his guardian, who has given the guarantee, will still be held liable for making such payment. Let's understand it more clearly. Like Mr. A, son, Ram has taken a loan, education loan from the bank, and the repayment arises. So in this case, though the principal debtor is free or discharged from his liability, but still the guarantor, that is surety, that Mr. A, who has given the guarantee, will be liable or held liable to make the payment. Next, we come to types of guarantee. There are basically two types of guarantee. First, specific guarantee. When a guarantee is given for a single specific debt or transaction, it is called specific or ordinary transaction or guarantee. When, for example, like Mr. A has given guarantee for the education loan of his son Ram. So this is termed as what? a specific guarantee which is being given for a specific transaction. And the second one is continuing guarantee. But the guarantee extends to a series of distinct and separable transactions. It is continuing guarantee. Like for example, AB traders is dealing with CD traders for certain quantity, for certain commodity. Like for example, chairs. And for that, they are undergoing for series of transactions for the period of time. That is for the year 1920, they are entering into transactions every month. So for that particular transaction or for those series of transactions between AB Limited, AB traders and CD traders, Mr. X has given a for uh, guarantee for making the payment in case of AB traders default with with CD Traders Limited. So whenever AB Limited and AB Traders and CD Traders are entering into contract, the guarantee for non-payment or default will be held by X for all the 12 months under which they are going for the transaction. Or we can say X has promised CD traders that whenever a transaction between AB traders and CD traders undertakes, the guarantee will be held by Mr. X. This is termed as what? Continuing guarantee, which is taken for a series of distinct and separable transactions. It is termed as continuing guarantee. Now we come to discharge of guarantee. When does the guarantee discharges or the guarantor gets discharge of his liability? Discharge over here means free from all his obligation. When does guarantee comes to an end or the parties are discharged or are freed from whatever liability or obligation have arisen from the contract of guarantee. The guarantee may be discharged by in the following manner. First, a notice of revocation. If the parties agrees to revoke the contract, revocation by the surety or revocation by the debtor or either of the party. If the parties revoke or cancel, revocation means cancellation. If the party, that is the guarantor or the debtor or creditor, has cancelled the contract and they have given such notice to all the parties, that is termed as what? All the parties are discharged or freed from their liability, respective liability arising out of that particular contract. Notice in the written form is sent to all the parties. Second, death of surety. In case the surety, that is the guarantor who is giving such guarantee, dies. In that case, the contract of guarantee given by the surety automatically discharges, that is the obligation that so arise from the contract has been ended. Next, radiation of contract. If in any way the debtor and creditor without any without informing the surety makes any changes or any variation in the contract, that automatically discharges the guarantor from all his liabilities. The next is release or discharge of principal debtor. In certain cases, if the debtor is released from his liability, be it by taking an excuse of certain time period from the creditor or by any other means, then automatically the surety or the guarantor also discharges. Like for example, A has taken loan from B for rupees 50,000 and the guarantee has been given by C. A has already paid 45,000 rupees and now he is unable to pay the 5,000 amount. And A and B are in very good terms. So B has discharged the liability of 5,000 or foregoes the liability of 5,000 in the sake of the transaction entered between them. So hence, as the debtor discharges from his liability of 5,000 amount, similarly, the surety also gets freed from all his obligations. Next is loss of security. Along with the guarantee, the debtor has to give certain amount, certain commodity or certain property as security and to cover up the loan amount. And if the creditor by his mistake loses the security, then in that particular condition, automatically the debtor gets discharged and so does the surety. Automatically the contract of guarantee comes to an end. And last, creditors act or omission impairing surety's eventual remedy. It means if by any act of creditor, if he is making any changes in the contract, he does not inform or he forgot to inform the debtor, the guarantor, or if he knowingly, unknowingly loses his security, in both the conditions, the it releases the principal debtor. So the principal debtor is released. So does the surety also gets discharged from his liability. It is giving a remedy to the surety for getting away from all his liabilities by any act or an omission or a commission by the creditor. That is, if the creditor loses the security, automatically the debtor is freed and automatically a remedy is given to the surety for not paying the amount. Now let's have a look at the rights of surety. What all are the rights of the surety or the guarantor against the contract of guarantee? So we start with as we have three parties, so the rights will be also three manifold. The first right is against the creditor. First right is right to benefit of creditors' securities, as the surety pays the amount in case of debtor's default. Automatically all the benefits of the securities so enjoyed by the creditor will be transmitted to the surety. Secondly, right to claim set-off. If any kind of claim set-off is there, like for example, Mr. A has lended money from B for rupees 1 lakh, and out of which there is a previous loan amount, there is a previous transaction between B and A where B has taken 10,000 rupees as on credit. So the loan amount which A will now be paying would be 1 lakh minus 10,000, that is 90,000. So if Mr. A, that is the debtor, is paying 90,000, similarly Mr. X, who is the surety, will also pay 90,000 only. So the right to claim set-off, that is the set-off which is being between debtor and creditor, will also be enjoyed by the surety. Surety will not pay 1 lakh rupees, but he will pay 1 lakh minus 10,000 that is payable by B to A. The remaining amount 90,000 will be paid by both the debtor and the surety in case of debtor's default. Next comes right against principal debtor. First and foremost right is right of subrogation. Right of subrogation means after the payment of debt on debtor's default, automatically the surety is given the same rights as that of the creditor. It means now after making the payment of the loan amount or in case of principal debtor's default, automatically surety has paid the amount and he enters into the shoes of the creditor as a new creditor for the debtor. So now all the rights that are enjoyed by the creditor would be enjoyed by the new creditor, that is the surety. Then next is right to claim indemnity. Right to claim indemnity, obviously this particular amount which the surety is making payment on behalf of debtor is a loss to him. That is not an amount which he has earned or which he has used. So that amount is a loss in case of surety. Like for Mr. A, X has given the assurance of making payment to B. So now after making the payment of rupees 1 lakh, to X, to Mr. B by X, automatically that amount of 1 lakh rupees will be a debt given by the surety to the debtor. Hence, it now the principal debtor has to make good this particular loss that the surety has borne by making payment on his behalf to the creditor. So he has a complete right to claim back the amount which he has paid as a debt to the creditor. So this is termed as what? Right to claim indemnity. Make good the loss which the surety has borne by making payment on principal debtor's behalf when he defaulted to the creditor. Next is right against co-surety. We have three manifold rights. First is creditor, second is debtor, and third is co-surety. First, we understand what is co-surety. When a guarantee has been given by more than one person, those people are termed as co-surety. Like for a loan amount given to Mr. A of rupees 10 lakhs by B, Mr. X, Y, and Z, three people have given a guarantee. So, X, Y, and Z will be termed as co-sureties, the guarantors who are coexisting. So, they have certain rights as well. First, liabilities of co-surety when contributing equally. If for the loan amount of 10 lakhs, all the three parties are contributing in 1:1:1 ratio, then all the benefits of securities and all the benefits of new creditor will be enjoyed by them in equal ratio. Whereas when the co-sureties have agreed to guarantee in different sums, like for example, Mr. X is paying 5 lakh rupees, Mr. Y is paying 3 lakh rupees, and Mr. Z is paying 2 lakh rupees as guarantee. So in this particular case, all the rights, all the securities, all the benefits of the new creditor will be enjoyed by them in the ratio of 5:3:2. That is the different sum that they have agreed upon to pay. This is all for contract of indemnity and guarantee.